Hey everybody, Matt Johnston here, and I am back with some COVID-19 vaccination guidance. So I go on vacation for a few days, and what does the EEOC do but issue brand new guidance related to vaccination programs under discrimination related claims and laws, such as the Americans with Disability Act and Title VII, which it covers discrimination. So I'm going to put a link to the show notes down below that you're going to see that's going to have information on that guidance. Uh, while you're down below, it would also be nice if you would click that subscribe button and click the bell, and that will tell you when we have new information available. So once the CDC came out with guidance that suggested that fully vaccinated individuals were not required to wear a face mask in pretty much every scenario, absent state, local, and other federal laws, I started getting a lot of questions. And some of the questions were, what do I do about vaccination programs? Can I require a vaccination program? Can I require my employees to show me documentation that they have been vaccinated? So our good friends at the EEOC decided that they were going to provide some of that information, and they did so while I was traveling to Florida. Rather rude of them. So the first thing that a lot of people are asking me is, under federal law, can an employer require a COVID vaccination for all employees entering the workplace? And the answer is yes, with some caveats. So you do have to meet some requirements. Under the Americans with Disabilities Act, you can require that everybody have a vaccination in order to come back into the office, but you do have to provide exceptions for somebody with a disability that would prevent them from getting a vaccination. And if an employee comes to you as the employer and says, I need an accommodation, you should be involved in the sort of the dialogue that is required under the Americans with Disabilities Act. But there is something else that an employer has to do, and that is do a direct threat assessment. A direct threat assessment means that if you have an unvaccinated employee who's going to be in the workspace, if they pose a substantial risk of harm or a significant risk of substantial harm that can't be eliminated by a reasonable accommodation, you do have to engage in some additional things. So if you do that assessment and you're not sure what you should do, you should absolutely contact counsel so that we can work through that. So if somebody has a disability that would prevent them from getting a vaccination, you do have to go through the reasonable accommodation process, and you do need to do that reasonable accommodation assessment. The other exception is if somebody has a sincerely held religious belief, practice, or observance that is covered under Title VII, which is sort of the standard discrimination, the basic discrimination law, federal law. So if somebody has a sincerely held religious belief that prevents them from getting a vaccination, you also have to go through the reasonable accommodation. So what are some examples of reasonable accommodations? Well, you may permit telework. You may also move somebody in a place, in your workplace, to isolate them off or protect them from other employees. You could also have a complete job reassignment if that is something that you can do. All of these accommodations have to be reasonable, and they have to not necessarily provide an undue hardship on the employer. Now, one of the questions that I've been getting asked quite frequently is if I'm going to require a vaccine and an employee refuses to get it on political grounds or something along those lines, can I terminate that employee? The answer is probably. You would likely be in a legal scenario where you could do it, but most counsel are probably going to recommend that you don't, and you find some other mechanism for managing it. But you can engage in that activity so long as it's not discriminatory and doesn't violate any other laws or statutes. Terminating an employee who refuses to get a vaccine is going to be a very, very hard decision to make, and it is one that you absolutely should be discussing with counsel before, and I stress that again, before making the decision to terminate an employee. A better scenario might be try to find a way in which you can provide an accommodation, whether that's telework, whether that is some other sort of agreement. One consideration might be some individuals are concerned about the fact that the Food and Drug Administration has permitted the use of vaccines under what is called an emergency use authorization. So that's not their standard review of a medical procedure, medical device, or a drug or a vaccine. And you can say that within 30 days of the Food and Drug Administration issuing a full use authorization, the employee will be required to get it. And in the meantime, you'll have some sort of reasonable accommodation. Now, I understand that some workplaces, it's going to be impossible to have employees teleworking. It's going to be impossible to have employees segregated off. So you are going to be faced with questions about accommodations, reasonable accommodations, and how you are able to engage in allowing employees to work separate from other vaccinated employees or other employees. So it's not an easy decision. It's not an easy analysis, and I understand that. But the EEOC is not in the business of making it easy. They're in the business of enforcing anti-discrimination laws. So in the next video, I am going to talk about what our good friends at OSHA have done, and we will talk to you in another video. Before I sign off, be sure you click the subscribe button that you're going to see right up here, and if you want to see other content, you can click this button right up here. In the meantime, go out and watch some live soccer. It's going to be a great summer for it. Talk to you later.